to today's webinar, and I hope you all are staying healthy and sane in these very unusual times. Hopefully you can all see my screen during the webinar. Please feel free to use the question box, typically located in the control panel to the right side of your screen, to submit questions. I've tried to integrate into this presentation all of the typical questions and answers that I have been fielding over the past week with respect to the Families First Act. But to the extent you have any questions that weren't covered in the presentation, of course, please feel free to submit your questions. If I can't get to all of your questions during the time we have together, I will try to respond via email after the webinar. And a recording of the webinar will be available later this week. So with that said, let's dive right in. As you are probably aware, President Trump signed the Families First Coronavirus Response Act on March 18th. The leave provisions become effective on April 1st, 2020. The April 1 is highlighted and underlined for a specific reason. When the bill was enacted on March 18th, it had a 15-day effective date, meaning it was going to be effective 15 days after March 18th, which by anyone's math is April 2nd. Under recent guidance that the Department of Labor put out just this week, they have changed that effective date to April 1st. I assume this was just for their own ease of administration, but it is important to note that it is an April 1 effective date. There are a few main provisions of the bill which we will dive into in greater detail here, but first, to be clear, this act applies only to employers with fewer than 500 employees total. So if you have more than 500 employees, feel free to jump off this webinar now. This act does not apply to you. If it does apply to you, there are two components to keep in mind. The first, 80 hours of emergency paid sick leave, and the second component is 12 weeks of emergency FMLA. There are specific exceptions for employers who have less than 50 employees, and I'll dive into those specific exemptions as we go through. I've put this chart in here to try and help employers understand exactly what they may be required to provide employees, and at the end I'm going to circle back to this chart. But needless to say, if you have fewer than 500 employees, both the paid sick leave and EFMLA provisions are going to be applicable to you. If you have fewer than 50 employees, you may be exempt from the paid sick leave to be used for child's school or daycare closures, but all other provisions for paid sick leave are going to be applicable. If you have fewer than 50 employees, you may also be exempt from the emergency FMLA provisions. Those same exemptions apply to employers with fewer than 25 employees, but if you have fewer than 25 employees and the EFMLA is applicable, you may be exempt from certain restoration rights. This is a high-level overview. Don't have to memorize it. We're going to dive into each of these specific exemptions as well, but this is just to get you thinking about where we're headed. So starting with the first main provision of the Act, the emergency sick leave. If you have fewer than 500 workers, you will have to provide on starting April 1st, up to 80 hours of paid sick time off. And that is applicable only to those employees who cannot work or who cannot telework. Said differently, if an employee qualifies or has a qualifying event for the paid sick leave, but is capable of teleworking or working from home, they would not be entitled to paid sick leave. Employers must front the money for the paid sick time off and then will be reimbursed by the federal government as part of their quarterly tax payments. And I will go through the process of requesting those reimbursements at the end of the presentation. So the emergency paid sick leave eligibility buckets, as I'll refer to them, come in two main swaths. The first three buckets really apply to someone who is individually caring for themselves or who is individually ill. So paid sick leave may be applicable if you are subject to a COVID-19 quarantine or isolation order, if the employee has been advised by a healthcare provider to self-quarantine due to COVID-19 concerns, or if the employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis. One frequent question has been, are the current stay-at-home orders that are being issued by numerous states, does that count as a quarantine or isolation order? I'll dive into this again because it's probably one of the most frequently asked questions that I receive. And at this point, my understanding is that a stay-at-home order is not the type of order that would be a quarantine or isolation order as contemplated by Congress. In other words, simply being subject to a stay-at-home order where you're not ill or not qualifying for any other paid sick leave criteria means that you would not be provided paid sick leave under the Act. The second swath of buckets for paid sick leave involves an employee who is caring for others. And in bucket 4, that could be an employee who is caring for another individual who is subject to a COVID-19 quarantine or isolation order, or where the employee has been advised to care for somebody who has themselves been advised. Let me start that again. The employee is caring for someone who themselves have been advised by a healthcare provider to self-quarantine. And then the last bucket for paid sick leave is when an employee has to care for a child whose school or daycare has closed due to COVID-19 precautions. It's important to understand exactly what the paid sick leave benefit entails. For full-time employees, you are eligible for up to 80 hours of sick time. For part-time employees, the 80 hours is prorated based on the equivalent of their average hours worked in a 2-week period. And sick leave is available for immediate use starting April 1st. The amount of pay that an employee receives for their paid sick leave depends on which of those paid sick leave buckets they fall into. If they fall into the first swath of buckets on caring for themselves, so at the top of this screen and the top rows, where the employee is subject to a COVID-19 quarantine or isolation order, they themselves have been advised by a healthcare provider to self-quarantine or are experiencing symptoms of COVID-19. For those absences, sick leave is paid at the employee's normal rate of pay up to $511 a day. For the second swath, bucket 4 and bucket 5, where the employee is caring for others, sick leave is paid at 2/3 of the employee's normal rate, up to $200 a day. And it's important to keep this in mind because the government is only going to reimburse you up to the permissible amount. And what I mean by that is if you have an employee who is taking paid sick leave to care for a child whose school has closed, and you pay that employee up to $511 per day, you will not be able to be reimbursed by the government for the difference between the $200 a day and the $511 a day. So for this reason, it's important to document which type of leave the employee has taken and to pay the employee appropriately based on their type of leave. A few other notes on the sick leave pay itself. The wages required to be paid under the emergency sick pay provisions will not be subject to the 6.2% Social Security payroll tax that's typically taken out of employees' wages. Paid sick time will not carry over from year to year, and it's important to note that the provisions of the Act expire on December 31st, 2020. Employees do not get 2 or more shots at paid sick leave between April 1st and December 31st. They can maximum take up to 80 hours of leave. There's not a situation where the employee would take 80 hours of leave in April for a qualifying event and then have a different qualifying event in June and take another 80 hours. It's solely 80 hours in total. A few more comments on employer obligations around this paid sick leave provision. Just because you already offer some sort of paid leave does not exempt you from the Act. So that means if you offer an unlimited PTO policy, or if you've already provided paid vacation or paid sick time to the employee, that doesn't mean that those provisions are going to exempt you from having to provide the paid sick leave. And you cannot require an employee to use that other available paid leave before using the sick time. And that may be a little counterintuitive, but keep in mind that an employer's provided PTO or vacation or sick leave does not carry with it the job protection that the paid sick leave under the Federal Act does. And just a quick note that there is also a very narrow exemption if you are an employer that has employees who are healthcare providers or who are emergency responders. You as the employer may elect to exclude those employees from the emergency sick leave provision. You know what, a lot of questions around the paid sick leave involve, how do I manage this practically speaking? How do I document that employees have a need for leave? What kind of paperwork can I request or require from them? I would say keep abreast of any new DOL regulations that might come out on this particular topic. But if no further regulations come out, you do need documentation to show which bucket of paid sick leave was utilized. This is both for payment and reimbursement purposes. I suggest that for every absence that's going to be qualifying as paid sick leave, you have some sort of form or checklist that marks which bucket they fell into and on which date for purposes of payroll administration, and also for purposes if you were ever audited by the government on this topic. And as to the type of documentation that we can require of an employee to prove the need for leave, that still remains somewhat unclear. In the absence of further guidance from the DOL, default to your customary and reasonable documentation practices, meaning if an employee is out on paid sick leave and your practice is to require a doctor's note after 2 days worth of absences, then you can request a doctor's note. Similarly, if you have any reason to believe that the employee is not being truthful or accurate with respect to their need for leave, you can follow your normal and customary investigation procedures to try and determine whether this is in fact a good faith use of paid sick leave. A few other points. Employers will have to post a notice containing information regarding these paid sick leave provisions. And the Department of Labor, I believe actually just last night, has issued that particular notice. It is available online. There are some very recent question and answers on how to post the notice and where to post the notice. Breaking news, if you will, that this notice can be provided electronically to employees, particularly if you have a large population that's working from home. You would follow your normal procedures of posting it in the workplace along with your other federal and state posters. And you do not have to translate the poster into various different languages, but you do need to make sure that all current and new employees receive a copy of the poster or have access to it. In terms of timing of the paid sick leave, it's important to know that the leave provisions go into effect April 1st and expire December 31st. If you allow employees to take paid sick time before April 1st, that time does not count for purposes of the Act. You certainly can provide employees paid sick time prior to April 1. You simply will not be able to seek reimbursement for that paid leave from the government. And effective April 1st, those employees would be entitled to the 80 hours provided under the Federal Act. If you're concerned about your ability to afford this, you're not alone. There are some specific exemptions for those employers with fewer than 50 employees. The Secretary of Labor will issue regulations that we still do not have yet, but for those employers with fewer than 50 employees, you do not have to provide the paid sick leave for bucket 5, those that need leave to care for a child whose school or place of business is closed. All other paid sick leave buckets, buckets 1, 2, 3, and 4, are applicable. Now, that the need to take leave to care for a child whose school or place of business is closed may be a heavy hitter. Hopefully your workforce has stayed healthy and people themselves have not come down with COVID-19 symptoms, have not been quarantined, and are not caring for people who have been quarantined. If that is the case, if your population is healthy, and if you're an employer with 50 employees, you may have a relatively little liability for the paid sick leave, since you may be able to be exempt from bucket number 5. Now, the exemption only applies when the imposition of having to provide this type of leave would jeopardize the viability of the business as a going concern. And what we have heard from the DOL on this so far is that to elect this small business exemption, you should simply document why your business with fewer than 50 employees meets the criteria I just described. We should see more regulations on this forthcoming, but the Department of Labor has already said explicitly to not send any materials to the DOL seeking this exemption, which means, or as I'm interpreting it to mean, that this small business exemption is going to be almost on an honor code system, and that you should have documentation to support why you chose to exempt yourself from the Act, but that you will not need to proactively seek an exemption before you are not required to provide the paid sick leave for employees who have to be off work to care for a child whose school or place of care has closed. Some common questions and answers I get on the paid sick leave. I know I addressed these earlier, but I want to make it pretty clear because I seem to get these questions over and over again. Does a state's stay-at-home order qualify as being subject to a COVID-19 quarantine or isolation order? And the answer is, at this time, no, unless the DOL guidance or regulations broaden the current definition of a quarantine or isolation order. Next question. What protections do employees have under the Act if they do not meet any of the paid sick leave buckets, but they refuse to come to work out of fear of getting sick? And the answer is that they don't have any protections. An employee who is well and who self-quarantines themselves is not eligible for paid sick leave. Next question. So if an employee can telework, even if they qualify for a paid sick leave bucket, they are not eligible for any of the paid sick leave buckets. Is that right? Correct. If an employee can telework, they are not eligible for any paid sick leave. Natural next question is, what if an employee is capable of teleworking in their role, but states that they cannot telework because caring for their children at home prevents them from being able to be productive. And I would say there's a couple of ways to interpret this act. Certainly one interpretation is that if an employee is effectively unable to telework, they would be eligible for paid sick leave. This may be a question of whether you want an employee purportedly working full-time at home and paying them full-time at home salary, even if their productivity is at 60 or 80%, or perhaps lower than 60%, given that they have perhaps children or small children running around at home. It may behoove you to force that employee or allow that employee to take the paid sick leave and then be reimbursed for that if the employee really is not capable of performing their work. I'd also say, though, that there is a stricter construction of the act, which would say if you're capable of teleworking, you are not eligible for the paid sick leave. So this is sort of a gray area, but I would continue to look for further DOL guidance on this point. Next question, what if I offer unlimited PTO? How does that policy interact with this federal paid sick leave? You can continue to utilize your PTO policy. If the employee has an absence that qualifies, though, for the family's first paid sick leave, you may be able to seek reimbursement from the government for all or a portion of that leave. So in essence, you would be running the PTO unlimited policy concurrent with the paid sick leave, so that in essence, the employee is receiving their full pay, but at least as the employer, you get the ability to be reimbursed for a portion of their leave. And of course, you should document the dates on which you ran that employee's leave so that there is not just a secondary bucket of 80 hours of paid sick leave to be used at some point if you decide that you're not going to continue your unlimited PTO policy. What if I decide to give employees leave before April 1st? Is there any chance I can seek reimbursement for that under the Family First Act? The government has come out and said fairly clearly no. Paid leave prior to April 1st cannot be reimbursed. And regardless of what was provided, employees will become eligible for 80 hours of leave on April 1st. That wraps up the paid sick leave provision. There is also a provision for emergency family leave. So don't space out on me even if you happen to have fewer than 50 employees and are not traditionally subject to FMLA. The emergency family leave provisions apply to every employer who has fewer than 500 workers, even if you have fewer than 50 workers and don't qualify normally for traditional FMLA. And under the emergency FMLA provisions, such employers will have to provide 12 weeks of EFMLA for eligible employees who are unable to work or who are unable to telework, because they have to care for a minor child if the child's school or place of care has been closed. So to be very clear, EFMLA only applies to someone who is unable to work or telework because the minor child's school has closed. It does not apply, EFMLA does not apply to those other paid sick leave buckets we discussed. EFMLA is specific to the child's school closure. And for EFMLA only, forget the traditional requirements that an employee has to work 1,250 hours in the last 12 months. If you are an employer that has 50 or more employees usually, and you traditionally offer FMLA, you can continue to utilize the traditional FMLA criteria with respect to those who need leave for a serious health condition or to care for a family member with a serious health condition For all of the traditional FMLA provisions, they remain intact. But for EFMLA only, throw those eligibility criteria out the door. For EFMLA only, all employees who have been on the job for at least 30 days are eligible. And that 30 days is calculated looking back from the date that their leave would start. So if an employee requests EFMLA on May 15th, you're going to look back 30 days from May 15th. And the paid provision of the EFMLA is a little wonky. Remember, FMLA is traditionally unpaid. And if you are an employer with more than 50 employees, for traditional FMLA uses, serious health condition, or to care for someone who has a family member with a serious health condition, FMLA remains unpaid. For emergency FMLA only, there is a paid component. So for EFMLA, the first 10 days of leave can be unpaid. Of course, an employee can opt to use either their accrued PTO or paid sick leave from bucket 5, the bucket of caring for a child whose school has closed, during that 10-day period so that they are paid. The remaining 10 weeks of EFMLA leave is paid at 2/3 of the employee's normal rate, up to $200 a day. So if an employee seeks leave on April 1st because their school has closed for the rest of the year, for the first 10 days of that leave, that employee can use paid sick leave that's going to be paid at 2/3 of the employee's normal rate, up to $200 a day. And for the remaining 10 weeks of EFMLA, they'd be paid at that exact same rate. And just like with the paid sick leave, the wages required to be paid for the EFMLA provisions are not going to be subject to the 6.2% Social Security payroll tax. So employers with 50+ employees, please keep in mind that EFMLA is not 12 weeks in addition to traditional FMLA. If you're an employer with 50+ employees and you traditionally offer FMLA and someone has utilized 6 weeks of FMLA for their own serious health condition, effective April 1st, they would have 6 weeks of EFMLA available as well. They do not get an additional or new 12 weeks of EFMLA. Employers with fewer than 50 employees, you may be exempt from the EFMLA requirements, just as with the paid sick leave, if the imposition of the EFMLA requirements would jeopardize the viability of the business as a going concern. And as we talked about before, to elect this exemption, you should document why your business meets the criteria that will be set forth by the Department of Labor. Let's assume, for the sake of argument, that the EFMLA provisions do apply to you. Generally, the employee on leave must be restored to his or her prior position. If you are an employer with fewer than 25 employees, you would be exempt from this restoration requirement if the position held by the employee who was on leave no longer exists because of the economic conditions or other changes to your business because of the COVID-19 pandemic, and if you as the employer make reasonable efforts to restore the employee to an equivalent position. A common question that gets asked is, can EFMLA be taken intermittently? Certainly you've probably heard that traditional FMLA can be used intermittently. EFMLA cannot. So if an employee said to you, well, I'd like to care for my child whose school has closed, but I want to take that leave in a 2-week increment here. I want to come back for 2 weeks, and I'm going to be out for 2 weeks again, back in the office, etc. It's in your discretion as the employer to allow that intermittent leave, but you are not required to provide the leave on an intermittent basis. Instead, the employee would have to take it all in one lump sum. So circling back to my chart here, hopefully it makes a little bit more sense now. But again, certain exemptions apply to those employees who are with fewer than 50 employees, but those exemptions are limited just to an employee's need to take paid sick leave or EFMLA to care for a child's school, for a child when their school or daycare has closed. If you have fewer than 50 employees, all other provisions of this Paid Sick Leave Act are going to remain in effect. And then again, if you have fewer than 25 employees, the restoration requirements of EFMLA may not be applicable. So a couple of common Q&As on EFMLA. Remember, the 30-day requirement is not 30 days prior to April 1st. An employee is eligible if they've been on the payroll for the 30 calendar days immediately prior to the day their leave would begin. Second question is, we're an employer with less than 50 employees and have not had to administer FMLA historically. What documentation do we need to support the need for EFMLA? And that's a fabulous question. Of course, I asked it myself. If you use traditional FMLA, you're familiar with the Department of Labor issued certifications that typically go to a third party like a healthcare provider who attests to the employee's need for leave. We have not been provided any certification, documentation, or attestation by the DOL yet. And it's a little bit of an interesting quandary. If an employee is saying that they need leave because their child's school has closed, it's really the employee themselves that would be certifying or attesting that they don't have the ability to work or telework because of that school or daycare closure. Certainly, an employer could seek confirmation from the school or daycare that it in fact has closed, but that's not been an issue that the DOL has yet to address. If the Department of Labor doesn't address this issue in its regulations, I recommend at least seeking some form of written documentation from the employee where they attest to the need and the nature of the leave. So of particular interest to most employers is how exactly am I going to get reimbursed for the paid sick leave and EFMLA that I'm providing to my employees. The government has been fairly clear that employers should receive 100% reimbursement for any paid leave that's provided under the Act. And employers should face no payroll tax liability for that. And the way this will work in practice is through your quarterly payroll taxes. So remember, if you're providing paid sick leave, the credit depends on which bucket the employee has utilized the need for leave. But you would be reimbursed for up to 100% of either the $511 per day or the $200 per day provided to the employee. Same concept with respect to EFMLA. And I believe that there will be guidance coming out, I thought this week, if not this week, next, on this issue. But the Department of Labor has said already that eligible employers who pay qualifying sick or EFMLA will be able to retain an amount of the payroll taxes equal to that qualifying paid sick leave and EFMLA that they paid, rather than deposit them with the IRS. And the payroll taxes that are available for retention include federal income taxes and both the employee and employer share of Social Security and Medicare taxes. And that's with respect to all employees, regardless of whether or not they've taken the leave. And if there are not sufficient payroll taxes to cover the cost of qualified sick and child care leave paid, employers will be able to file a request for an accelerated payment from the IRS, which at this time they expect to process in 2 weeks or less. So giving some examples of how the DOL expects this to work in practice. If an eligible employer paid $5,000 in sick leave and is otherwise required to deposit $8,000 in payroll taxes, including taxes it has withheld from all of its employees, the employer could use up to $5,000 of the $8,000 in taxes it was going to deposit for making the qualified leave payments. And the employer in this circumstance would only be required to deposit the remaining $3,000 on its next regular deposit date. If, on the other hand, the eligible employer paid $10,000 in sick leave and was required to deposit only $8,000 in taxes, the employer could use the entire $8,000 of taxes in order to make the qualified leave payments, and then should file a request for an accelerated credit for the remaining $2,000. A number of employers, particularly those who are more than 50 employees but less than 5,000 and therefore are not potentially exempt from the need to provide paid sick leave or EFMLA for employees taking leave to care for a child whose school has closed, have expressed concern about their ability to actually pay those monies out. And one question of importance is, if I place an employee on an unpaid leave of absence, such as a furlough or a temporary layoff, does the Act apply to me? Unless we have further DOL guidance that says the answer is no, I believe that the answer is, in fact, yes. If an employee is on an unpaid leave but remains on your books as an employee, if they have a qualifying need for paid sick leave or EFMLA, they would be eligible for that paid leave. However, the Act, of course, does not apply if employees are terminated. So now I'll turn and see if there are any questions. And it looks like we do have at least one. And the question is, are the 50 employees cut off the same requirements for FMLA, meaning full-time direct employees within the United States? With respect to EFMLA, I believe that the guidance suggests that those employees, that the employees for purposes of counting are all employees regardless of whether they're full-time or part-time. And if that doesn't answer that particular question, of course, feel free to email me afterwards, and I'm happy to discuss further. It looks like that is all the questions that we have had so far. I'll take that to mean that I've done an excellent job of incorporating all of the hundreds of questions I have previously gotten on this topic into this webinar. But of course, if I haven't answered anything, I'm happy to talk after the webinar. I appreciate your time and attendance. And again, I hope you and your families are staying healthy during this very difficult time. And I guess I should probably follow up with the closing comments that I was supposed to read. If you are not currently receiving our updates and invitations, we invite you to go to Thompson Hine, our website, and register to receive our mailings under the Publications tab. We do issue regular updates on a variety of topics, including the coronavirus, and that is an excellent resource to stay up to date. So thank you again for your interest in attending today's webinar, and I hope you enjoy the rest of your day.